Today we're going to talk about code words in covert employment discrimination, which seems to exist in almost all cultures, but more specifically in organizations that tend to have a dysfunctional organizational culture. So let us begin from early childhood years. Children are born with an open mind. They don't necessarily say, okay, I got to discriminate against this group of people or that group of people, or short people or tall people or white people or black people or men or women. However, we become socialized in the cultures where we live. Therefore, eventually we end up using our biased information or biased perceptions to make workforce decisions in terms of who to hire, who to promote, and so on. So this is why the focus of today's presentation is code words. Certain stereotypical code words can be evidence of discrimination in any organization, be it public sector or private sector.
Employment discrimination is a big field in the law, and specifically I'm going to focus in on United States law, and in particular the Civil Rights Act 1972 as amended. And this act prohibits discrimination in all the terms and conditions of employment based on certain protected categories. In the original act, race, color, national origin, religion, gender. And then, of course, we have additional civil rights statutes. We have the Age Discrimination in Employment Act, which prohibits age discrimination, and we also have the Americans with Disability Act, which prohibits discrimination against the disabled. So there's a big body of employment discrimination law. But all this law is premised on having some evidence of discrimination. And that's how I want to relate code words to the overall body of anti-discrimination law. Now, the Civil Rights Acts, they all apply to the terms and conditions of employment. That's hiring, promotion, a transfer, assignments, a suspension, discipline, discharge, termination. However, initially, I want to focus in on the discharge aspect of the employment relationship and show you how code words has an influence on discharge from a substantive and a procedural vantage point. Now, regarding discharge, the most important point in the United States is the states in the United States are employment at will states. And what does employment at will mean? It means if an employee at will, he or she does not have a contract with their employer that limits the circumstances under which they can be discharged. That means they can be discharged for no reason, no good reason, even the old cases say a morally bad reason, perhaps like nepotism. However, even employees at will cannot be discharged for an illegal reason. Discharging someone for an illegal reason, that creates a wrongful discharge lawsuit. Right? So how does code words apply to all this? An employee at will who's discharged and who wants to fight that termination, perhaps on grounds that he or she was discriminated against during that discharge because of a protected category, their race, their color, their gender, their age. That aggrieved employee needs evidence that they were treated in a disparate manner. Disparate simply means a different manner. That's the disparate treatment theory of employment discrimination law. However, a mere assertion of disparate treatment is insufficient. The aggrieved employee needs evidence. This evidence of disparate treatment, different treatment based on race or color or any other protected categories, this evidence can be direct evidence, which is very clear evidence indicating that a decision maker in the company had a discriminatory motive. The court used the words a discriminatory animus against an employee, say because of the employee's race. The employee needs some evidence. Now, say it's a sex discrimination case, if a decision maker says, we don't want any women working here, you should be at home having babies and baking cookies, whatever. Well, that's, nice, clear, direct evidence as to why someone was discharged or maybe didn't get the position. That evidence is hard to come by. Direct evidence, because most people are not running around saying, I'm a racist, I'm a sexist, sue me in federal court. That's why we use the word covert in the title of this little presentation, because evidence of that discriminatory motive can be direct evidence, very clear evidence, or the evidence can be indirect. The evidence can be circumstantial. The evidence can be inferential. In other words, certain words, certain facts, certain circumstances can give rise to an inference of discrimination. And what can those words be? Those words can be code words. Now, some code words are so blatantly sexist and racist, I'm not going to use them here, that basically they're equal to direct evidence. But others are not. Those are the more covert words. Let me give you an example. So just a recent case. And for example, saying to an employee that the employee is overly talkative, is gabby. Court will, that doesn't raise any inference of discrimination. But calling an employee uppity, that raises an inference of a discriminatory motive, because uppity, at least here in the United States, based on a past very sad history of racial discrimination, segregation, and my goodness, going back to slavery in the Old South, uppity has a certain connotation. It's a very negative connotation. So calling someone gabby, overly talkative, courts have ruled, those are words that don't give rise to an inference of discriminatory intent. Whereas calling an employee uppity would. Or saying that someone is not hired because we don't want to work with any poor people. Well, what's wrong with poor people? What's wrong with those words? Well, there can be a lot wrong with them, because the courts have said those words can be construed as code words as to why you're discharging or maybe not hiring an employee, an African-American employee, because they're poor people, which is basically an inference that there's a stereotype against people because of their race. And another case, and actually this is a Supreme Court case, so this is the Supreme Court case dealing with code words, and it dealt with the use of the term boy. Once again, what's wrong with the term boy? Boys and girls, right? Well, there can be a lot wrong with the term boy. In this particular case, it was a plant manager refused to promote 2 African-American supervisors. Why? Said they weren't qualified. But the evidence indicated that the plant manager kept on calling these black supervisors, they were men, obviously, kept calling them boys. Well, guess what? According to the Supreme Court, that raises an inference of discrimination. In other words, the African-American supervisors didn't get their promotion, not because they weren't qualified for it, but because they were discriminated against because of their race. And what was the crux of the case? The code word, singular, the one word, boy. And once again, based on the sad history here in the United States, that was used as a very negative racial term in the old days of, as I said, slavery, segregation. And no matter how old and mature and accomplished an African-American man was, the put down, the very negative insult and put down, the racist insult was to call such a person a boy. So that's what code words can do. Calling an older employee overqualified. Well, what's wrong with that? It's good to have so many qualifications, isn't it? Yet, discharging an older employee because he or she is overqualified or not hiring them, the courts have ruled that is an inference of age discrimination. How do we know what words are good words and which words are bad words? Well, the courts tell us on a case-by-case basis. And there's a body of law that's developed, and it's very interesting, dealing with which words are permissible, like someone being gabby or overly talkative, and which words, so for example, towel head, which the courts have construed as giving rise to an inference of discrimination. So, if there is precedent, or if you can convince a court to create a precedent that certain words are code words that give rise to an inference of discriminatory intent, then the case can move on. Note that I said the case can move on. It doesn't necessarily mean that the aggrieved party, the discharged employee, the employee didn't get promoted, didn't get the job, doesn't necessarily mean that he or she prevails. So, for example, in a discharge type of situation, if the employee can use code words to raise an inference of discrimination, what is the result? The result is, as I said, the employee doesn't automatically prevail, but then the burden of proof and persuasion is shifted over to the employer, and now the employer has to come up with legitimate job-related reasons as to why the employee didn't get the job, didn't get the promotion, and why the employee was discharged. Now, of course, the employer may come up with some reasons, but then what can the employee do? The employee can provide evidence that the employer's reasons are fake, illusory, pretext. It's called the pretext doctrine in the law. And what can the employee use to establish pretext evidence? Well, direct evidence, or once again, circumstantial evidence, our old friend, code words. So it's interesting to see in the cases that code words can be used to create an initial inference of discrimination, to reverse the burden to the employer, and then when the employer comes up with legitimate job-related or purported legitimate job-related reasons, then code words can be used a second time to show that the employer's reasons were fake, illusory, merely a pretext. A pretext for what? A pretext for discrimination, for discriminatory intent, for having a discriminatory animus against the employees. So, as I said, the employee needs some evidence in a disparate treatment case. The evidence can be direct or circumstantial, meaning indirect. And what can provide evidence to create an inference of discrimination? For circumstantial evidence, code words can. And then it's a matter of going through the cases to see what words are permissible, code words, like someone is gabby, overly talkative, and which words the courts have ruled are impermissible code words that give rise to an inference of a bad intent, discriminatory intent, such as calling someone uppity. And they said the cases are very interesting indeed, and it's something that, in particular, HR managers should be concerned about. And of course, as always, you want to have a diversity training to make sure that people are treated fairly and equally, and to avoid all types of stereotyping at work. Thank you.
An employer may be able to discriminate in hiring by preferring motivated job applicants, but if that motivation standard results in hiring of only young employees from one specific gender or race or religion, then that employer could be sued, even though the intention was to hire people who are motivated. So what are the implications for managers? Prevention is always better than asking for forgiveness. This is why it's important to do a diversity audit of the organization in the culture to see whether the organization's culture is more exclusive or more inclusive or somewhere in between. And obviously the goal is here to move toward an inclusive culture, so managers and employees can basically use the right language and the right terminologies for communication. The words we use do matter. We need to be very, very cautious in terms of how our managers, our supervisors communicate, how they make their promotion, discharge, and hiring decisions. And we need to make sure that they choose their words carefully, decide fairly, and in all cases act professionally. In summary, code words can be linked to illegal discrimination. Managers and human resource professionals in all institutions, firms, and organizations should conduct diversity audits on a regular basis about their organization's culture to see what words, what phrases are being used that could be considered as code words when they're making hiring, promotion decisions in their organization. Managers must create a workplace that accommodates people of all backgrounds and abilities, so long as they can perform the job, so long as obviously they're qualified for the position. So be fair, be legal in all of your employment decisions in the workplace.
دلخانه‌ای تو بلبل باشی و دلانه‌ای تو کمر باری کتاب کودکان گردد به مکتب برد درد من و افسانه‌ای تو کمر باری که من شام تاریک من کمر باریک من شام تاریک من بیا به نزدیک من سالها صفا کن جفا دیگر است با ما وفا کن کمر باریک با ما وفا کن کمر باریک با ما وفا کن کمر باریک پرگلی من برگ زردم تو شوره خندهی من آهی سردم کمر باری توی شم و منم پروانهی تو مرا بگذار تا دورت بگردم کمر باری که من شام تاریک من کمر باریک من شام تاریک من بیا به نزدیک من ساها صفا کن جفا دیگر است با ما وفا کن کمر باریک با ما وفا کن کمر باریک با ما وفا کن کمر باریک دختر بلای آسمانی گهی با ما گهی با دیگرانی کمر باری خدایت دادم و روی زیبا ولی سنگین دلم نامهربانی کمر باری که من شام تاریک من کمر باریک من یا به نزدیک من صلح و صفا کن جفا دیگر است با ما وفا کن کمر باریک 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 دل عاشق مثال